கவர்னர் பதவியும் ராஜ்யசபா பதவியும் மற்றும் இருக்கின்ற லோக்பால் பதவிகளும் அளிக்கின்ற போது அவர்கள் இயக்கங்களை என்ன தீர்ப்பு சொல்லியிருப்பார்கள் என்பதை நாம் ஊகிக்க முடிகின்றது. அதனால்தான் நீதித்துறையிலே அப்பாயின்மெண்டே வெளிப்படைத்தன்மை இருக்க வேண்டும். தெரியும் யார் யாராவது அப்பாயின்மெண்ட் தெரியறது கிடையாது. தெரியாத போது அவர்களை பற்றி விஷயத்தை சொல்ல முடியாது. அந்த வெளிப்படை தன்மை வேண்டும். நீதித்துறை தவறு செய்கின்ற நீதிபதிகளுக்கு நடவடிக்கை எடுக்கின்ற ஒரு மெக்கானிசம் இருக்க வேண்டும். ஆனா எந்த தவறு செய்தாலும் உயர் நீதிமன்றம், உச்ச நீதிமன்றம், நீதிபதிகள் மீது நடவடிக்கை எடுப்பதற்கு எந்த வழியில் தீர்ப்பு இல்லை. ஒன் இம்பீச்மெண்ட். இம்பீச்மெண்ட் உங்களுக்கு தெரியும். ஜஸ்டிஸ் ராமசாமி மீது வந்த போது என்ன ஆயிடுச்சு, அதற்கு பிறகு இன்னும் நீதிபதிகள் மீது வந்த போது என்ன ஆயிடுச்சு தெரியும். இதுவரையிலும் எந்த நீதிபதியும் இம்பீச் பண்ணதே கிடையாது. காரணம், ஒரு அரசியல் கட்சி ஆதரிக்கும் ஒரு கட்சி இருக்கும். இப்படிப்பட்ட ஒரு நிலைமையில் இருந்து உள்ளது. எனவேதான் நீதித்துறையில் நேர்மை இருந்து நேர்மையாக இருக்க வேண்டும், தீர்ப்புகள் நியாயமாக இருக்க வேண்டும் என்ற வலியுறுத்துவதற்காகத்தான் நீங்க நீதித்துறையின் நியமனத்தை வெளிப்படுத்தோடு இருந்தால்தான் வேலை நடைபெறும் என்பதற்காகத்தான் தொடர்ந்து வழக்கறிஞர் சங்கம் வலியுறுத்தி வருகின்றோம். நீதித்துறையில் நீதிபதி நியமிக்கின்ற போது வெளிப்படுத்தல் இருக்க வேண்டும் என்பதற்காக என்ன செய்ய வேண்டும் என்பதை பற்றி வலியுறுத்தி தொடர்ச்சியாக சீதாராமன் கொண்டு வந்த அந்த தனிநபர் தீர்மானத்திலிருந்து தொடர்ச்சியாக வரிசையாக வலியுறுத்தி கொடுக்கிறோம். நாங்கள் இதுவரையிலும் முறையாக இல்லை. எனவேதான் இதற்காக இன்றைக்கு அனைவரும் அமைதியாக இருக்க கொண்டிருக்கிறார்கள். இது பத்திரிகையும் சரி, மற்ற ஊடகங்களும் சரி, இங்க நடக்கின்ற தவறுகளை சுட்டி காட்டுவதற்கு கூட முடியாத அளவுக்கு முடக்கப்பட்டிருக்கிறது. கருத்து சுதந்திரம் என்பது முழுமையாக தடை செய்யப்பட்டிருக்கிறது. ஆக இப்பொழுது ஒரு 75க்கு பிறகு மீண்டும் ஒரு எமர்ஜென்சி நாம் சந்தித்துக் கொண்டிருக்கிறோம். அதற்கு உறுதுணையாக நீதிமன்றமும் நீதித்துறையும் இருந்து கொண்டிருக்கிறது. இதை மாற்ற வேண்டும் என்கிற எண்ணத்தை உருவாக்குவதற்கு, மக்கள் மத்தியில் செல்வதற்கு வழக்கறிஞர்களால் மட்டும்தான் முடியும் என்ற காரணத்தினாலே இதை மக்கள் மத்தியில் கொண்டு செல்கின்ற பொறுப்பு நமக்கு இருக்கிறது. அந்த அடிப்படையில் தான் இந்த கருத்தரங்கத்தை நாம் ஏற்பாடு செய்திருக்கின்றோம். இந்த கருத்தரங்கத்தில் நீதித்துறையினுடைய ஜுடிஷியல் அக்கௌண்டபிலிட்டி, என்ஷூரிங் டிரான்ஸ்பரன்சி அண்ட் இன்டெகிரிட்டி ஆஃப் ஜுடிஷியரி என்ற தலைப்பில் நம்முடைய டாக்டர் எஸ் முரளிதர் அவர்கள் இப்பொழுது பேசுவார்கள்.
Very warm good morning to everyone. நடுவில் தமிழ் பேசுகிறேன். இங்க இந்த வரவேற்புக்கு மிக்க மிக்க நன்றி. I think this is the first public talk meeting after limiting office in Chennai. I am deeply grateful to the All India Lawyers Union, and in particular to the President Balasubramanian, Secretary Srinivasan, State Executive President Poland, State General Secretary Shivakumar, and Vice President ILU Chennai, Gopal Ram. I am deeply honored that many senior members of the bar are here, including Prasad sir, who is a doyen of the bar here. He has seen several generations of lawyers and judges, and one has learned so much from his writings and his handling of cases, particularly on this topic of accountability in judicial. On 27th of January this year, an extraordinary event took place in the Supreme Court of India. 5 judges sat on a Saturday morning to handle a very peculiar situation. That situation was a single judge of the Calcutta High Court and a division bench of the Calcutta High Court being at loggerheads. The question was about handing over the investigation to the CBI, which the single judge had ordered, which order had been stayed by the division bench. When that order was shown to the single judge, he refused to abide by it and said that my order will still stand. So while this ping pong was going on, the Supreme Court stepped in to say both the matter before the single judge and the division bench will now stand transferred to the Supreme Court of India. It brought before a serious issue concerning judicial discipline, more importantly, about judicial accountability. Last week, the YouTube was full of one particular video clip by the American talk show host, John Oliver. There are so many students in the audience. I wonder if you've heard of this video by John Oliver. Anyone has seen it? Nobody's seen it. The focus of John Oliver's talk was the Supreme Court of the United States. He was pointing out how judges of the US Supreme Court had no code of conduct to govern their actions on the bench and off the bench. If you watch that video, you will realize that there are so many disturbing details that he gives of the conduct of the sitting Supreme Court judges of the US. As you know, in the US, there is a federal system, there's a state system. You have Supreme Courts of the states, and in the federal system, the apex body is the Supreme Court of the United States. There was a judge by the name of Abe Fortas in the US Supreme Court in the 60s, who was accused of taking fees to give a legal opinion in a case which was going to come up before the Supreme Court of the US. It became a huge scandal. Abe Fortas was compelled to resign. That episode made them announce a code of ethics in 1969. But strangely, they exempted Supreme Court judges in the United States from the applicability of that code. John Oliver in this show, in this episode on the courts of the United States, points to the irony of this, that the trigger for the code of ethics there was the misconduct of a Supreme Court judge. But the judges sought to exempt themselves from the applicability of that code. He points to three specific instances. One involving Justice Kavanaugh, one of the recent appointees to the US Supreme Court, who'd been trying to sell a ranch in Colorado of his for several years without success. Within a few months of his assuming judgeship in the Supreme Court of the United States, he managed to sell it. He had to disclose it, but left the name of the purchaser blank. It so turned out that that purchaser was the head of a major law firm, which had more than 20 cases going on in the Supreme Court of the US. He points to another instance of Justice Samuel Alito, who was funded expensive vacations in Alaska. And since all of this is on Facebook and internet, there was no secret about where he had gone, who had hosted him. Then the question arose whether private vacations by judges need to be disclosed. But when they found that even the price of one salmon fish was $1,000, questions were raised whether judges were given extraordinary benefits for being judges at the instance of private parties. But most disturbingly, and I say most disturbingly, John Oliver talks of the conduct of Clarence Thomas, a sitting judge of the US Supreme Court, whose wife, Virginia Thomas, is a very active member of the Tea Party, which is an extreme right-wing faction of the Republican Party there. Virginia Thomas had tweeted to the leader of the Republican Party while the Capitol Hill incident was actually happening on January 6th of 2021, where she says how Trump must be saved at all costs. John Roberts points out that there were several cases even now pending in the US Supreme Court concerning the incidents at Capitol Hill. But Clarence Thomas never accused. He also points out to luxury vacations given to the Thomas couple by 4 billionaires in the US, many of whom have cases going on in the Supreme Court of the US. I think in the wake of all these scandals, and law students should be here aware, the US Supreme Court has for the first time in its history published a code of ethics for its judges on 6th November 2023. It is available on the net. where they expect judges to act according to their conscience and not accept gifts from persons who are unrelated, who may have cases before the court, things which should have been obvious to everyone. Why I'm mentioning all this is we always seem to look at countries outside to set our standards because we have an inherited legal system. We inherited the system from the common law system. We've continued with that. So when we formulate either provisions or laws to govern the conduct of judges, including the provisions set out in the Constitution, we borrowed these concepts of what should be the correct way the judges should conduct themselves. What is propriety? What is accountability? We've grappled with these issues for quite some time. If we go back to the Constituent Assembly debates, the expectation of Dr. Ambedkar was that judges would know what they're expected to do and what they're not expected to do. The expectation was holders of high constitutional offices need not be told what they should and should not be doing. But our own experience the last 75 years shows that there are many problems in expecting judges to self-regulate. In this country, we have not only judges who've taken on the onerous responsibility of finding which are the best persons to appoint to the high courts and the Supreme Court, but also the honest responsibility of having an internal mechanism to regulate the conduct of judges, both of which have left with deep dissatisfaction among not only the legal fraternity but members of the general public. One way to look at it is that it's a work in progress. But the other disturbing feature is it's 75 years of an experiment in progress. And maybe it is time, particularly after so many reports on the functioning of the judiciary. Mr. Farid Nariman, who passed away very recently on 21st of February, points out that there are as many as 200 reports, including law commission reports, on functioning, on the various aspects of the functioning of the judiciary. And very little of those reports have actually been acted upon, either by the government or by the courts. We've had the Judges Inquiry Bill of 2010, which seeks to amend the Judges Inquiry Act of 1968, which has not gone through. We have the Judges Accountability Standards Law, which was floated during the UPA regime, which seems to have been buried and not revived. So all that we have to fall back on are the Bangalore principles, preceded by the restatement of values of judicial life. Because there are so many students of law here, I must point out that the Bangalore principles of judicial conduct, which has been implicitly adopted by our Supreme Court, has a whole chapter on impartiality. It says it's the second value, number 2 is impartiality, and I'm agreed. Impartiality is essential to the proper discharge of the judicial office. It applies not only to the decision itself, but also to the process by which the decision is made. I'll just read 4 clauses which I think are very important, and I must preface this reading by pointing out that whenever we talk of the judiciary, we should not think only of the Supreme Court and the high courts, where the pendency of cases is over 80,000 and over 70 lakhs respectively, but also of the district judiciary. Now it's not politically correct to call them subordinate courts, although the Constitution uses that phrase. I use the phrase district judiciary, which will mean not only the district court, but all courts hierarchically below the district court. The district judiciary plays a very, very vital role in the administration of justice. And very often in our debates, we seem to lose sight of that fact. And we focus, I would think, disproportionately on the high courts and the Supreme Court, of course, which need that focus because their decisions have a binding effect and lay down the law for several people. But the subordinate courts deal on a daily basis with people's lives in a very direct sort of way. And the conduct of the district judiciary, therefore, has to also come into sharp focus. So these principles would apply equally, I repeat, equally to the district judiciary. I must share with you that in Orissa, after 2021, I took over in January 2021, we revived the practice of the annual meeting of the district judges with the High Court judges. We call that in Orissa the District Judges Conference. I'm sure there is a counterpart conference here in Tamil Nadu as well, where the district judges come over a weekend to discuss issues which concern their functioning. And one of the sessions which they themselves wanted to discuss on was judicial ethics. Today, in the age of social media and internet, I will share with you, many subordinate judges have genuine concerns about what is the right thing to do. One of the judges posed this question. She said that the witness was in the box and answering questions, and the cross-examination had just begun and had been, kept back for the following day. When there was a series of WhatsApp messages in the group formed by the judges themselves concerning the conduct of this very witness in some other issues. So the question the judge posed is, what am I supposed to do? Do I say that having seen this clip, which has the effect of influencing the way I think about this witness, do I stop hearing the case? Somebody else posts a Facebook, a photograph. So in the age of social media, with judges not being outside the circle of social media, and I'm talking of judges of the district judiciary, I'm sure it's happening in equal measure among judges of the High Court and the Supreme Court. Somebody praises a political leader. Somebody talks very highly of a ceremony that has taken place. Something has religious overtones. Something has caste overtones. How do we stop these influences? How do we stop judges from getting affected by these things? How do judges insulate themselves? Another judge posed a very valid question. She said, I'm married to a person who happens to be the managing director of a multinational company. And he's hosting a party for the corporate sectors, the big honchos in the city, or maybe in the country. She says, am I supposed to stand with him as hosts for the party? Many of them may have cases in the courts. What is the right thing to do? Genuine question. We may not have easy answers to this. One answer would be, having assumed a public office, you're expected to make certain sacrifices. You're expected not to mingle in these crowds. But then you have several roles to perform. You're a spouse to a person, who's in a very important, influential position in business. Do you give up your career, or does he give up his career? These are difficult questions. So these issues will constantly rise, and with changing times, the challenges become even more severe. Children are in practice. Children have grown up with you. Do you stop being a judge? Do they stop becoming lawyers? Always a question. All these principles, and I'm going to read some of them to you, insist that lawyers who are children of judges should not operate from the residence of that judge. They should have their offices outside the office or the house of the judge. But looking at the lawyers here who've had years and years of practice, one of the first things that the lawyers do is find out who's related to the judge and what way. And from the age of Cicero, I'm talking of Cicero being the Roman, great lawyer of the Roman times, lawyers who are keen to win cases for their clients will find various ways of achieving that result. So this challenge of trying to influence the outcome of proceedings in court by engaging people who are known to the judge or have an influence on the judge is a battle that's been going on for a long time. So young students in the audience should know that this is really one of the oldest professions, the legal profession. And very soon you will realize that you're dealing with human beings who happen to be judges at various points in time. And having assumed those offices, you expect those persons to transform themselves. Maybe not overnight, but definitely progressively. You expect them to be persons who can overcome their prejudices, overcome their biases, And this phrase that you so often hear, justice should not only be done, but seem to be done. So what you're looking for as an essential value in a judge is impartiality. And there are various aspects of the function of courts and the legal profession that directly affect this perception of impartiality of judges. You will find this being affected because of the judge belonging to a certain caste, a certain community, a certain region, a certain class, a certain chamber. The judge happens to have worked with a very senior lawyer like Mr. Prasad. So people will desperately try and engage Mr. Prasad to appear before that judge. But Mr. Prasad will say, listen, this person has been my own junior, how can I appear before him, right? So there is a way of misusing this. You don't want Judge X to hear the case. You want the judge to recuse herself or himself. You engage and review the judge to file a talaknama. A constitutional judge will say immediately, not before me. The result is achieved. This is not a new phenomenon. This is not a new phenomenon at all. This is as old as the legal profession itself. But judges are expected to rise above this. They're expected to be aware that there will be people trying to misuse the proximity to the court, the proximity to the judge, and others who will try to use these people to achieve a certain result. Which is why you need people with sufficient experience in the bar, real experience of practice for being appointed as judges, because they will be aware and conscious of these efforts to distort the outcome of a case. So just coming back to the battle principles now that I've given you a background, when you now listen to what has been said, and these are universal standards that we are talking about, a judge shall disqualify himself or herself from participating in any proceedings in which the judge is unable to decide the matter impartially, or in which it may appear to a reasonable observer that the judge is unable to decide the matter impartially. Such proceedings include, but are not limited to, instances where, and these are the instances pointed out, the judge has actual bias or prejudice concerning a party or personal knowledge of disputed evidentiary facts concerning proceedings. Now, this personal knowledge, whether the judge has personal knowledge, is only known to that judge. It will very often be not known to the lawyer appearing before the judge, definitely not the litigant appearing before the judge. So much depends on the judge acknowledging this personal knowledge. The personal knowledge can come through various sources. It can come through a neighbor, it can come through an old acquaintance, it can come through watching, like I said, a WhatsApp clip. It can come through a former judge of the court, a sitting judge of the court, a judge of the Supreme Court. It can come through any source. Once it becomes personal knowledge to the judge, to expect the judge to continue to decide the case impartially is asking for a lot. And it's only the judge who can disclose that. So sometimes you have that instances. I think there's an instance from the Madras High Court itself, which became quite a controversial thing about a judge being tried to be influenced by a phone call from a minister, which and it was then inquired into. We do not know what was the result of that inquiry. I'm so sorry. No. This personal knowledge affecting the outcome of the proceedings should be flagged. The second instance, the judge previously served as a lawyer or was a material witness in the matter it controls. If you look at the schedules to the Arbitration Conciliation Act, Schedule 6 and 7, they list out the instances of possible bias. So one of the instances of bias, which is now statutorily acknowledged as applicable to arbitrators, is the judge previously serving as a lawyer or a witness in the matter in controversy. So if people are looking for what is the correct code of conduct for judges, you may want to look at the code of conduct prescribed statutorily for arbitrators. And if it can apply to arbitrators, of course, it has to apply to judges. What we found in the Orissa conference is many judges of the district judiciary were not even aware that these principles exist. We seem to circulate and talk about these principles only in their applicability to high courts and the Supreme Court, and not in relation to the district judiciary. And I think it's a major failing. I think it should become part and parcel of the academic trainings, the judicial academies all over the country. And there should be an entire capsule on ethics, which actually discusses these issues. Just to point out again this apparent bias. How many of you have heard the name Antonin Scalia? Anyone here? In this entire audience? Yes. Who was he, please? Yes, he was a judge of the US Supreme Court. He's no more now. Scalia went for duck hunting with the then Vice President of the United States, Dick Cheney. And Cheney's cases involving Cheney's actions were pending in the Supreme Court. So the question was, should Scalia continue hearing the cases with, this particular case? Now, the US Supreme Court, they sit en banc. En banc means everybody sits together. There are 9 judges of the US Supreme Court, they all sit together. They have a rule that when an application is filed for recusal of one judge, it is that judge who has to decide whether the judge should recuse or not. So this recusal application went before Justice Scalia himself. And Scalia refused to recuse. He said, duck hunting expedition is not going to change my view. He made a very interesting observation. He said there are 9 of us sitting, and to win a case, it will be 5-4. So if you take me out, you're actually taking out the vote of a petitioner who can succeed. So what are you achieving? You're really not achieving anything in the end. So he argued that because the court's opposition was such, it did not matter whether Scalia continued to hear the case or not. And it is this that has set back the code of conduct formulation for the US Supreme Court, and it has taken, I think this duck hunting Cheney opinion was delivered in the early 2000s, and it's taken another decade, 2 decades, for the US Supreme Court to come up with a code of conduct for its own judges. So the point really is about the perception. Can you say justices seem to be done? Can you know that the Vice President is a dear bosom friend of one of the judges of the US Supreme Court, and his conduct is being examined in a case before the Supreme Court? And is it fair? Can you expect the court to be impartial? You could still argue, as Scalia has argued, that after all, I'm 1 out of 9 judges. What difference does that make? He also brought in what is called the doctrine of necessity. So for students of the law, you should know that doctrine of necessity is shown as an exception to the doctrine of bias. This was explained in the case of Subramanian Swamy versus the Election Commission of India, where Subramanian Swamy wanted the disqualification application not to be decided by Mr. T.N. Session, who was the Chief Election Commissioner, because he said they had a troubled past where there was animosity, and he didn't expect a fair decision. There was a discussion of the doctrine of necessity. If there's only one person holding the post of the Chief Election Commissioner, and it is only that person who was to decide for the Election Commission of India, then the doctrine of necessity comes in, and despite there being a bias, that person still has to decide. Fortunately, in that case, by the time the matter came up for decision, it had become a 3-member commission. So they said that T.N. Session would convene the meeting of the commission, but will not participate in the proceedings. He would then stay away from the proceedings. If there's a split vote, he might come in, again, because of the doctrine of necessity. But if the decision is not a split decision, that becomes a decision of the Election Commission of India. So the doctrine of necessity, which even Scalia pleaded, he said our Supreme Court is a Supreme Court of 9 judges. And because one judge happens to know a party on close terms, does not mean that that judge has to refuse. The third instance that the boundary principles talks of, the judge or a member of the judges' assembly has an economic interest in the outcome of the matter in controversy. You will recall how Justice Kapadia once recused because his son was either a retainer or employed by one of the firms So he announced this in public. Here, judges can do one or two things. One is they straight away recuse, or they adopt what many arbitrators do, they disclose their interest. They say this is the interest that is there in the case involving me and my family member. Does anyone have an objection to my continuing to hear the case? Very recently, the Madras Bar Association case about non-members having access to the facilities in the Madras Bar Association reached the Supreme Court of India and was listed before a bench of Justice Suryakant and Justice Vishwanathan. Justice Vishwanathan had recently been felicitated by the Madras Bar Association after he assumed office of Supreme Court judge. So when the case was called out, Justice Vishwanathan, as was right for him to do, announced saying that I've been recently honored by the Madras Bar Association, and they are the main respondents here. Does anyone have an objection to my hearing the case? Of course, the lawyers were unanimous in saying, no, we have no objection to your hearing the case, but they still deferred the case because of this. Justice was not only done, but seemed to be done. So now the case is coming up before a different bench of which Justice Vishwanathan is not a member. I'm mentioning this because there are two ways of therefore dealing with this. When there's a large court and when it's only to your personal knowledge what your interest might be, it's better that you volunteer, you disclose that fact to the lawyers and say, oh, you still want me to hear the case. This many judges do. In fact, judges go to a different level on this. I know instances of sitting judges of the High Court, at least two instances. One, Justice Aluwalia, who's now retired, of the Punjab and Haryana High Court, when his children entered the bar and they were going to practice in Chandigarh, he volunteered. He wrote to the Chief Justice of India saying, can I be transferred to some other High Court because my children have entered practice, which is a very healthy thing to do. The other more recent example is of Justice Atul Sridharan, who's asked and who's shifted to Jammu and Kashmir High Court because his children are on the verge of entering practice. This, of course, these are healthy practices, but bar knows more on which children are practicing, where, before what court. So there is a code of conduct which says that the children should not practice in that court. Now, this has become the point of interpretation. That court means that very court where that judge is sitting, or the entire court where the judge is sitting. So the jury is out on this. Some judges believe it means the entire court. So when Justice Madan Lokur was sitting in the Supreme Court of India, his son would not practice in the Supreme Court of India. When Justice Bhatt was sitting in the Delhi High Court, neither his wife, later his son became a lawyer, would practice in the Delhi High Court. So they knew the entire court as being out of bounds to the spouse or children or near relatives. Another way that seeking to tackle this is, before becoming a judge, get a declaration from the judge concerned that the near relative of the judge will not practice in that court for, let's say, 2 years or a close number of years. So for which the judge has to volunteer that information, and that is a new trend that has started. I know Justice Mukta Gupta's brother, who is a senior lawyer, did not practice in the Delhi High Court, although not for 2 years. I think he stopped practicing for many, many years after that. This is something that has evolved over time, but it's a universally accepted thing that if the judge's family, any member of the judge's family has an economic interest, the judge will not hear the case. There's a whole chapter in the Bangalore Principles on integrity. The principle reads like this: integrity is essential to the proper discharge of the judicial office. A judge shall ensure that his or her conduct is above reproach in view of a reasonable observer. The behavior and conduct of a judge must reaffirm the people's faith in the integrity of the judiciary. Justice must not merely be done, it must also be seen to be done. There are numerous instances in our judicial history where we've seen a breach of this rule on the behavior and conduct of a judge. I spoke of the Calcutta incident. I mean, of course, the Supreme Court will deal with it. And when you look at the transcript of the proceedings in that court, you'll find the Chief Justice of India requesting the lawyers not to mention the action going on from both the courts, that is the court of the single judge, the division bench, saying, let's protect the dignity of the institution. There have been other instances, I can name a large number of them, where the embarrassment value has been very high. And judges have had to tackle this. 7 judges of the Supreme Court of India had to deal with an issue concerning a judge of the Madras High Court who stayed on the judicial side the administrative orders of the Chief Justice of the Madras High Court. So the Madras High Court had to approach the Supreme Court to get those judicial orders stayed. Of course, the matter didn't end there. I think all of that is part of judicial history. Again, students of the law, you are fortunate enough that today the internet, which never forgets anything, the complete history of this particular case that I'm talking about is already available for you, all of you to research, to read. It's a reported judgment of the Supreme Court of India. 7 judges sat and punished a judge of the High Court for contempt of court, sentenced the judge to imprisonment. The judge went underground, did not resurface. All of that is now part of judicial history, unsavory part of judicial history. Then you have instances of failed attempts at impeachment. As you know, the only way of removal of a judge of either the Supreme Court of India or the High Court, in our scheme of things, is by way of impeachment under Article 124. That is a tortuous, long process, and it has not met with any success so far. To explain to you in gist, basically the procedure that's been evolved is to have an inquiry committee set up under the Judges Inquiry Act, which is preceded by a resolution by members of certain majority of members of Parliament, and that resolution being adopted, the inquiry committee being set up, the inquiry committee being giving a report, which is placed on the table of the Parliament, which is debated upon, and which then results in a resolution, which is then given to the President to pass the order of removal. So again, the first known instance of this going up to the stage of Parliament was the case of Justice V. Ramaswamy. And as we know, probably read about it, although the inquiry committee found him guilty of the charges and the report was tabled in Parliament, the ruling party at that point in time, the Congress, which was in majority in Parliament, abstained from voting. And therefore the motion was defeated. The second and third time it happened was involving Justice Soumitra Sen, where again the report was tabled in Parliament, the report which found him guilty. But Justice Sen resigned before it could be voted upon. And another instance is of Justice P.D. Ditachan, where the judge again resigned before it could go to the next stage. I'm mentioning these instances because it has been found repeatedly that the all or nothing kind of an approach we have to judicial misconduct, that it has to be removed by impeachment and nothing short of that, has meant that much of this could not be corrected in the normal course of things. The Law Commission came up with a report on the judges' inquiry, where the Law Commission suggested that for lesser degrees of misconduct, judicial misconduct, there should be a range of other kinds of punishments like censure, like withholding of work, and so on and so forth. But somehow that has not been taken up for discussion, and still at the stage for many, probably it have to be worked upon. Another value that the Banking principles discuss is propriety. Propriety, the appearance of propriety are essential to the performance of all the activities of a judge. A judge shall avoid impropriety and the appearance of impropriety in all the judge's activities. So as a student of law, you may ask, what is propriety and what is impropriety? Right? This is like asking a sculptor of a beautiful statue of a lion. So they wondered, they said, how did you do such a perfect sculpture of the lion? So he said, for me, it was quite simple. I took a large block of stone and removed from it everything that didn't look like a lion. So very often lawyers and judges will tell you, when you explain a certain conduct of a judge, I can tell you whether it's proper or not proper. The judge who's not having judicial temperament in court. the judge being visibly angry. There's an excellent article in the Hindu just 3 days ago on judicial anger and how it can cloud the decisions of the courts. One of the first judges I sat in the Delhi High Court with was Justice Mukul Gurkar. And one advice he gave me, which remained with me for the rest of my judicial career, was this. He said there will be various points in your career as a judge where the judges or the litigant upset you, or maybe even a colleague sitting next to you upsets you, and you're passing an order in that frame of mind. He said you can take it from me 9 out of 10 times, that order is likely to be set aside by a higher court. Because your order, although it may be correct, will sound as a product of your imbalanced mind. So very often when we read orders, even if it's written in newspapers, you can make out whether the order was written in anger or in a calm, disposing state of mind. So what judges must eschew, and this is what we repeatedly keep urging in judicial academies when we talk to judges, is something has upset you very much, and you're in a kind of imbalanced state. Either take 2 sips of water, get up, retire to your chamber, calm yourself down, come back, or say pass it over. There'll be judges who rile you up, judges sitting on the bench. There will be no instances where the judges had disagreed on the bench. One judge has said something, which is hurtful, the other judge gets up and walks away. He's about unknown things. So that disturbed state is not the state in which judicial orders should be passed. You have instances where the lawyer misleads the court. I'm sure many of the lawyers here know all these instances so well for them to be like being another day in court. The case before your case is going on, and the lawyer has either misled the court, kept back a document, is unable to answer a question, and the judge is visibly agitated, very upset. And he's either dismissed it or adjourned it, and you can see the judge in a very disturbed state of mind when your case is called up. Now you're in a dilemma. Should I argue this case before the judge was in this disturbed state of mind? What should I do? So somebody like Mr. Prasad will know the mood of the court and calm the judge down a bit and say, these things do happen, and these are tough times for the judge and all of that, so that before the case is actually discussed, Mr. Prasad's case is discussed, the judge will be in a better frame of mind. Or ask the judge to say, take a pass on. This very often happens, particularly if your case is a difficult case. So orders passed in judicial anger, ultimately judges are human beings. So when I served as a judge, I knew that I was being very carefully watched by the bar. The bar wants to know what is it that uses this judge? What is it that irritates this judge? What is it that makes this judge sit up and take notice? Right? Some judges like a very interesting question of law. So before discussing the facts, the lawyer will say, sir, my lord, a very fascinating question of law. A conflict between 2 judgments. A proposition that has never been settled. So make that very attractive. Some lawyer who knows this judge is very technical, and who's on the other side will get up and say, Annexure 5 is unreadable, my lords. Judge will get very angry. What kind of annexure is this? What do you expect me to do? So each judge has a different way of approaching things. I had a conversation with Justice Jagannatha Rao, who's now, of course, who was the law commissioner. I happened to be the law commissioner, he was the chairperson of the law commission. He shared so many anecdotes with me. And as a practicing lawyer in these days, in the High Court of Andhra Pradesh, undivided Andhra Pradesh, he used to say how one judge will have, expect you to sacrifice your weak points. You have 4 points, you have 1 strong point and 3 weak points. So you first sacrifice point of, let's say, jurisdiction as a weak point, limitation as a weak point. You sacrifice those 2 weak points. On that strong point, you keep hovering over it. You don't state it so forthright, the judge will pick it up. When the judge picks it up, you say, my lord has put it so beautifully. So this is connecting with the court, right? Each judge has a different approach. And this is something that as judges we have to be aware of, that the lawyers will be actually studying us very carefully to see which is our weakness, which is our strength, what is it that makes us happy, like being shown a judgment of a colleague. This happens so often. I disagree with another colleague because our approaches are different. I'm a relief denying judge, he's a relief granting judge. I'm very particular on limitation being properly explained. That judge says it's okay, these things happen. Delay 200 days, 300 days, that judge says it's all right. And the judge says no. 200 days you have to explain to me. Every day's delay you have to explain to me. So two very different approaches. So in order to convince me that I should condone the delay, you show me the judgment of my colleague who's very liberal. I'll say no, don't show me that. This happens on a daily basis and it happens in all courts. Now, judges have to be deeply conscious of this. Judges have to know that this is the tipping point with the lawyers playing on. I must overcome that. Right? So, this is a big exercise for judges. That's why I see judges evolving and growing on the bench. Some evolve and grow in the right way, some of course don't, because the lawyers know how to play the judges. Right? This is, after all, a psychological exercise too. My senior used to tell me, knowing the law, knowing the facts is one thing, but communicating with the judge is so important. Ultimately, the judge has to pass an order. The judge has to be in the right frame of mind to pass the order. So studying the court, studying the mood of the judges, and presenting your point, therefore, becomes one of the essential exercises of a good lawyer. Now look at this. Now in this context, look at propriety and appearance of impropriety. As a subject of constant public scrutiny, a judge must accept personal restrictions that may be viewed as burdensome by the ordinary citizen and should do so freely and willingly. You're always the subject matter of attention. When you walk out into the marketplace, there is a PSO standing with you. You've come in a car, the police escort. You're getting into just a provision store. You're a signage of all eyes. Now you can't do anything that everyone else does. Let's say you're bargaining with the shopkeeper. They'll say this judge bargains shopkeepers. What is this? So you're constant public scrutiny. And today, with live streaming, you're in even more scrutiny. I'm sure you've seen those clips. Angry judge, right? Brilliant argument by the lawyer. And, all kinds of captions where you see those video clips. Of course, in Odisha, we made a conscious attempt at, those clips not being able to be used like this. Because this is upfront commercial. On YouTube, if it gets more than 1 million hits, the person putting up the clip benefits monetarily. So we had a strict set of instructions. But the point I'm making is the judge being under scrutiny. The judge sitting on the bench. Now you can actually see all that. The judge yawning, right? So judges have to be constantly aware that they're being watched very carefully, and therefore having to give up the freedoms which ordinary people have is part of being a judge. Because you're privileged, you're clothed with immunity. Like I said, you can't be removed from office except the way of impeachment, which is a very high threshold. In particular, a judge should conduct himself or herself in a way that is consistent with the dignity of the judicial office. So improper comments on the court, right? Even in private life, in functions, how the judges conduct themselves is very important. They may not have the kind of freedom even in their private lives. I keep telling everyone, one of the big changes that I sensed from being a lawyer to being a judge is as a judge, we live in a glass house. Where whether you had a headache in the morning, whether you skipped breakfast, they had a late dinner, whether you're watching television, all of this is known to at least 15 people. All the time. There's nothing like privacy for a judge. You're on a constant gaze. In fact, one phrase that my spouse developed was acquired helplessness. Where you can't open your own door, you can't carry your own file. Justice Chandru had a very nice way of describing. He says, the chamber, we all become Jesus Christ. We stand like this and the gown is then slip through our shoulders. Once you get used to this kind of lifestyle, that changes as a judge. That becomes a habit as well. So I made it very clear that I would open my own door. I would not have an usher. I mean, these are personal choices that I made. I'm not expecting every judge to do it, but we should not become slaves to the privileges of office. Main thing is that. being called my lord, your lordship. One of the things you sense after becoming a judge and after delivering, let's say, 3 or 4 judgments, you go to a bar function, somebody will come and say, sir, I have practiced in this court for 40 years. I'm yet to read a judgment like the one your lordship delivered. What great development of jurisprudence. So as it is, you get inflated, you get inflated even more. So you have to be very conscious that, the weakness that human beings have, the weakness of flattery. Judges should be very conscious of that. These are things people play on. Or being cited your own judgments. There was one lawyer in the Supreme Court who went before the judge of the Supreme Court and started citing one judgment of a particular high court. I won't mention the high court. AIR 1982, which high court name, page 344. Judge looks at it and says, very interesting. It's an judgment authored by him, that judge when he was in the high court. Then 1990, that high court sitting, Mr. Counsel, I was in the division. Yes, I thought she was in the division. Look at the language, he said, Counsel. Such clear, lucid language, what clear exposition. Far better than any Supreme Court judgment. Very happy. The third judgment, then he says, Mr. Counsel, how did you do such wonderful research? The judge is asking. The counsel without batting an eye, he says, before my lord, I cite only my lord's judgments. So this playing of the judicial ego. So the ego can both harm and distort. You can have a very inflated sense of yourself. Very soon, mine was deflated in no time. I worked very hard in the IPR judgment. I thought I'd done so much research and formulated principles, this, that, crafted the judgment. Even in the initial years as a judge, you burn midnight oil almost on a daily basis and you work hard because this is a new craft, right? You're teaching yourself to do. And you have good examples. You have a judgment of Bhagavati or Krishna here. You want to say, let me, try and reach that standard at least. And then 2 months later, an order is produced from the Supreme Court. It says, counsel on both sides very fairly stated that this judgment can be set aside. So you have to develop a sense of detachment also from your own products. These are ephemeral. The best of the judgments can be. We are in a space where even a Keshwana Nivarti can be opened. So we must be prepared. We must be prepared as judges to understand that what we say is not the final word, it will not be the correct word. It is changing times. Listen, the US Supreme Court, which delivered the Dred Scott case, the same 9 judges Supreme Court of the US, must have thought that they laying the law for many years to come. The Indian Jabalpur bench must have thought I'm laying the law for many years to come. The NM global judgment, those judges just last year must have thought they're laying the law for many years to come. Overturning judgments has become almost an easy thing now. So developing attachment to your own judgment is better not developed at all. This is the most temporary and ephemeral thing. A judge shall not participate in the determination of case in which any member of the judge's family represents a litigant or associated in any manner. Yes, I've told you this. Even before the brother judges, we call what is called the uncle auntie, right? My child has grown up with your child, right? They've gone to school together. Our families know each other. Certainly, my child will not practice in my court, but your child can certainly practice in my court. Now, how close we are, only we know, and maybe some members of the bar. So the members of the bar can try and exploit that. Suddenly, you will find lawyers being briefed who have actually nothing to do with that branch of laws. It could be an income tax case, it could be a criminal case, it could be some other case. But you'll find 4 lawyers sitting and the 5th will be this lawyer. Now, as a judge, you have to be conscious of this. What I'm saying is, this is nothing new in the bar. This has gone on for God knows how many years. But as judges, we should know that this restriction that members of the judge's family shall not participate need not be restricted to this sphere alone. It can go far beyond. Chamber junior. Haven't you heard this? So same chamber, sir. So this is something that only judges will know, only judges should be conscious of. And I'm again repeating, it's not just about the Supreme Court and the High Court. It's about all the courts in the hierarchy of courts. A judge shall not knowingly permit staff or others subject to the judge's influence. Now, time for some funny instances. So there is this district court judge, just a minute. Sessions judge, who's very proper. He will dictate the steno, facts, evidence, reasoning he will type himself. Meticulous. He will have his own typewriter. He has a combination of briefcase. He will type the conclusion, put it in that briefcase, come to the court. He will not even give it to his reader. He will himself take the packet and read the judgment. In that court, this kind of a judge, on the morning of the date of pronouncement of judgment, the newspaper will carry a headline, judge likely to convict, judge likely to acquit. So it was upsetting this judge very much. He says, I'm taking so much care and precaution, and how is this information leaking out? So inquiry. So full-fledged inquiry, and finally the needle pointed to the usher. The man who comes in and says, hissing, makes the hissing sound, pulls the chair for the judge to sit. So he asks his usher, you know this combination lock of my briefcase? He says, oh, no, sir. He says, sir, open sir. Sir, case get or witness பேசிட்டு இருப்பாரு. நீ ஈஸியா இப்படி பண்ணுவீங்க. இப்படி பண்ண ஆரம்பிச்சிட்டீங்கன்னா ஆக்சுவலி ஈஸியா முறுக்கே தெரிஞ்சிடும் கன்வெக்ஷன். So small gestures the judge makes, people notice. So that, for instance, tips. உங்களுக்கு bail கிடைச்சிருச்சு. There will be that guy with that sash waiting outside. He will give you a nice salam. The meaning of that salam is you got a relief. No? I am trying to get some relief. This is a practice in most courts. Judges have to be so. When I became a judge, I was very conscious of this. I said, in my court, this will not happen. I will not tolerate this. So when they told me one peon was doing it, I got him shifted out. Then another peon came. I didn't see him doing. So I called my PS. I said, now everything under control. He scratched his head. I said, what? He said, now he goes to the parking lot. So judges have to be deeply conscious of how the staff works, how matters get numbered. So if you're a practicing lawyer, you know all this. How cases get listed. So this mechanism of policing our system has to come from within. It can't come from without. For which we have to have a good vigilance system. So when as Chief Justice, I appoint a strong judicial officer as a vigilance registrar, behavior changes. When I make constant, so the listing branch in the Orissa High Court, we didn't allow anyone to continue for more than 3 months. Because whatever you might do, because this is the oldest profession, lawyers will wait. Lawyers will wait for the climate to change, for the weather to change. Dismissing judge, sir, let it go for default. He'll tell his client. Default will utru, sir. Apura install padikala. Who bench is very common. So I'm saying as judges, it's not that we're unaware of these things. We're aware. We should know what happens in a roster. Good roster, bad roster from the point of view of lawyer is relief granting, relief denying. ஒரு ஜட்ஜ் என்ன 482 போட்டீங்கனாலும் நோட்டீஸ் டேக். சந்தோஷம் பாரு. இந்த வருஷம் தான் ஜட்ஜ் ஓட நமக்கு. பார் புரிஞ்சு பண்றாரு. ஒரு ஜட்ஜ் எங்கேயே சொல்லிருக்காரு. சார் வக்கீல வச்சு ஒரு 2000 செலவழிச்சு ஆல் டே வந்திருக்கான் சார் டிஸ்ட்ரிக்ட்ல இருந்து ஹை கோர்ட்டுக்கு. வெறுக்கையோட திரும்பி போகும். மெரிட்ஸ் அதெல்லாம் கணக்கு இல்லை. வெறுக்கையோட திரும்பி போக கூடாது. So that's how our arrears keep mounting up. So we are not actually deciding on the merits of a case. We are saying that the lawyer needs relief. So this has become problematic. And then that case comes up after 5 years and 10 years. You look at it and say, who should notice this? How did they grant a stay?
So this being conscious of how the bar operates, how the system operates, and how you function as a judge is so important. Because ultimately we're all functioning as judges to affirm the rule of law. And the faith in the rule of law will go if something like this happens. I'm the complainant in my criminal case. The accused has gone and got a stay of the FIR extension. The case is not coming up for the next 5 years. What faith will I have as a complainant in the system? I will not have any faith. I'll say, sir, anything happens, it just goes into the wilderness. Nothing happens for 5 years, 10 years. So this Asian resurfacing case judgment, which has been reversed, I think it has its own repercussions. In the Odisha High Court, we found that cases were pending the subordinate courts for 30 years and 40 years. When we analyzed the reasons, one reason was that there's a stay granted by the High Court. Or, very simple, call for records. Seasoned lawyers will tell that judge in the CRT or the criminal division, so just call for record. So no stay, nothing granted. Call for record. Record has come, record is lost in the High Court. Nobody knows where the record is. And in the trial court, it's just adjournment after adjournment after adjournment. So 30 years becomes 40 years, becomes 50 years. Why it's in the High Court? In the High Court, we're searching for the bundle, you can't find the bundle. There's so many such cases. So one of the exercises we undertook in the Odisha High Court was to clear up all of this. We scanned all the lower court records and sent them back. We gave instructions on Asian resurfacing and said you have to strictly follow. No question will stay continuing beyond 6 months. So list the matter in the trial. So of course, some lawyers who were anxious came running to the High Court to say extend the stay, but many did not. So as a result, many of the old cases could actually be disposed of. Now I don't know what will happen because now the burden is on somebody to say don't extend the stay. Otherwise, the presumption is the stay continues. I think I'll be overshooting the time. I just want to mention one thing on the lesser degrees of misconduct, which we have to deal with. I'm talking about the C.K. Ravichandran Iyer case. Do we have time, sir? Okay. The C.K. Ravichandran Iyer case for students of law, you should know, was a case which stemmed from an instance in the Bombay High Court, where Justice A.M. Bhattacharya, who was then the Chief Justice of the Bombay High Court, had received unusually large sums. We're talking 80,000 pounds, 95,000 pounds, for royalties for the book that he'd already written some 20 years ago on Hindu law and Muslim law, which were hardly selling much. So this seemed to be an unusual favor done to him for a case which was pending before him. So the Bombay Bar was up in arms. And they decided to pass a resolution asking for his removal, which was passed in majority. And the judge finally resigned. But C.K. Ravichandran Iyer, who was a lawyer practicing, approached the Supreme Court saying, we can't allow bar associations to get together and by majority ask for removal of judges. We must have a procedure for removal of judges. That judgment saw the Supreme Court evolve what is called an in-house procedure. So, for instance, now, when there's an allegation that a judge is sexually harassed an intern, or a judge has shown undue favors, or a judge has misbehaved with a judicial officer, as it happened in Madhya Pradesh, you have an internal in-house inquiry committee set up as a Supreme Court. And on the result of that in-house inquiry, the matter is then further processed by the Chief Justice of India. So, Soumitra Sen's was one such instance where that in-house inquiry committee found that there was something to be said, and then the matter was processed, and he wrote to the Justice K.G. Balakrishnan, Chief Justice of India, wrote to the President and asking for impeachment. So this in-house procedure continues till date. So all the recent instances follow that in-house procedure, including the former Chief Justice of India, who was, as all of you know, was alleged to have sexually molested staff. And that case saw 3 judges of the Supreme Court hold an inquiry, give a clean chit to the judge, but that employee was reinstated in service after the Chief Justice of India debuted office. So all that is part of judicial history, it's part of the literature. But in Ravichandran Iyer case, looking at these intermediate acts of misconduct, judicial misconduct, which may not meet the high threshold of judicial misconduct for impeachment and removal, but for lesser degrees of punishment. This is what the Supreme Court said. The independence of the judiciary is most essential when liberty of the citizen in danger. Bad behavior of one judge has a rippling effect on the reputation of the judiciary as a whole. The edifice of the judiciary is built heavily on public confidence and respect. The court said the hiatus between bad behavior and impeachable behavior needs to be filled in to stem the erosion of public confidence in the judiciary. So in the Justice Ramaswamy case itself, the then Chief Justice of India, Sabyasachi Mukherjee, took the bold step of not allocating work to the judge. Of course, then the judge proceeded, when he was told that he's not going to be allocated work, the judge proceeded on long leave. It recently happened in Allahabad, when one judge was not allocated judicial work, and of course his case is now with the CBI, and for almost 2 years, he performed no judicial work at all. And this is what comes in as a result of this in-house inquiry. The other important case for you to study in terms of transparency is the disclosure of assets case. It started in the Delhi High Court, where Subhash Chandra Agarwal, who's the right to information activist, approached the Delhi High Court asking that assets of judges be disclosed, personal assets of judges. The single judge, one of the questions before the single judge was whether the Supreme Court of India is a public authority for the purpose of the Right to Information Act, particularly the Office of the Chief Justice of India. So it was the stand of the Supreme Court of India was that the CJI is not a public authority under the RTI Act. The single judge negated that. The single judge's judgment was affirmed by a full bench of the Delhi High Court. A further appeal was filed to the Supreme Court to itself. Now, this is again a doctrine of necessity. The Supreme Court is entertaining an appeal where the appellate is the Supreme Court. So anyway, fortunately the Supreme Court lost the case before itself. The Supreme Court affirmed the judgment of the Delhi High Court, particularly the proposition that CJI is a public authority, but said on a case-to-case basis on rules of privacy, it should be decided whether it's furthering public interest to disclose that information regarding the assets of justice or not. In the initial phase, when this case is going on, several high courts put on the net the assets of judges. Now that practice is stopped altogether. Even Supreme Court, I think the present lot of judges have not disclosed their assets. So somehow that move to have judges disclose their assets on the net has taken a back seat. But during the process of that judgment, certain observations of the Supreme Court are important for us to note. Accountability, the court says, defined narrowly, is a relationship between an actor and a forum in which the actor has an obligation to explain, to justify his or her conduct. The forum can pose questions and pass judgment, and the actor may face consequences. The narrow conception of accountability, however, suffers from a straitjacket view devoid of general guiding principles. Broadly, accountability is the search for normative values informed by democratic values that guide the exercise of power and freedom granted by the Constitution. The judiciary, like other institutions envisaged by the Constitution, is essentially a human institution. The independence of the judiciary was not envisaged to mean its insulation from the checks and balances that are inherent in the exercise of constitutional power. The independence of the judiciary is a constitutional guarantee of freedom. Notions of accountability, however, concern the manner and ends for which the freedom guaranteed is employed. Where judicial independence focuses on freedom, judicial accountability is concerned with the manner in which that freedom is exercised by the adjudicator. I was thinking about this. I think judges would be mistaken to think that this judicial power which they have is without responsibility or without accountability. Only because judicial independence is valued as part of the basic structure of the Constitution does not mean that judges are unaccountable for the powers that they wield. And they wield powers not only the judicial side, but also the administrative side. And indiscipline on either of these sides can be detrimental not only to the rule of law, but to the independence of the judiciary itself. Let me give you two small examples. Like the example in Calcutta. A single judge says, I'm not bound by the division bench. A division bench says, I'm not bound by the coordinate bench. A coordinate bench and a bench of two judges says, I'm not bound by a bench of three. It will be very detrimental to rule of law and to the independence of judiciary. In a hierarchy of courts, the court of a single judge is bound by the division bench. The division bench is bound by a larger bench of that high court. That larger bench is bound by the Supreme Court. In the Supreme Court, a bench of two is bound by a bench of three. Bench of three is bound by a bench of five. So if you have a difference of view with the coordinate bench, the only way to do it is to refer it to a larger bench. So we find the unhealthy practice of trying to distinguish judgments, only to overcome them and to say, no, that judgment is on a completely different set of facts, and therefore I do not follow that judgment. This is a dangerous trend which has to be stemmed, because otherwise it will undermine the faith in the rule of law. On the administrative side, there's a large element of misuse of power, like appointments to the various posts in the judiciary. Particularly class 4 posts. You will find some judge getting orders from above saying somebody should be appointed to that post. Likewise, this judge will call up a judge of the district judiciary and say, you are in charge of recruitment of peons to your district court. I'm sending you the names to appoint these names. So these are the things that undermine the faith in the system. You'll find there's a lot of litigation on appointments to the posts of staff in the high courts, in the district courts, because of this, because of favoritism, because of nepotism, and because those judges have tremendous pressure. I get a call from a high court judge. I can't refuse that call, right? I could get transferred, I could get punished. So I say, why should I take the responsibility? So this has to be set right. It can be done only by strong judges, being in important positions, who recognize that judicial power is connected, is integrally connected with judicial accountability, transparency. So you have to have advertisements for filling up posts. It has to be a public advertisement. It has to be a transparent process of recruitment. And if you do that, the faith in the system increases. Then they know that this court is really serious about the rule of law when it comes to the administrative side. I think we can be very arbitrary on the administrative side. One of the principles, code of conduct for the US Supreme Court, which they now got, is being courteous to your own staff. You will find many judges misbehaving with their staff. Many judges misbehaving with other judicial officers who've come to the High Court on deputation. This really hits at the morale of such officers when they are treated as subordinates, not worthy of respect. So this judicial power is a tremendous power, but this must be wielded with a great deal of responsibility and consciousness that although I may be acting on the administrative side, my actions are answerable to law, answerable in law. And as a decision maker myself on the administrative side, I have to follow the rules of natural justice. I have to give reasons for my decisions. And it should not be arbitrary. I should follow all those principles which I espouse sitting on the bench for the rest of the world to follow. So this consciousness is again very important. And the declaration of Essex case shows us the guiding principle for this transparency in functioning of the courts. So if you find on the website now, I think I can speak of the Orissa High Court. We have complete statistics on disposals, on pendencies, on arrears, where we are failing. How many old cases, how many 10-year-old cases, how many 20-year-old cases, how many 40-year-old cases? What are the reasons for the delay? If the court is not functioning for the full time, we give you in statistics how many actual working hours of the court were taken up and how many cases were decided. Because of strikes, we lost a lot of working hours in the court in Orissa. Once an order of the Supreme Court was passed and all the strikes came to an end, visibly the disposal increased. So there is a direct correlation to working hours in the court and disposal of cases. But we must put out that information. Only then people will understand how courts function, how the output of judges is intrinsically related to the number of actual working hours in the court. There should be more study of these things So merely increasing the number of judges will not solve the problem of even the full-time courts. Judges must work for their full capacity, for the full potential. If they have to sit at 10:30 and to get up at 4, they must sit for all those hours. You will find that in the afternoons, if you walk into the district judiciary, many judges are not sitting. They might do the court work and finish for the rest of the day. Some of the high courts you walk in the afternoons, you may find many courts not sitting. So this merely appointing more judges who will do this very thing will not increase the disposal of cases. There has to be a discipline that is enforced, which is self-imposed, and that's the hard work that the judges do. I must add here that in every court, be it the magistrates' court or subordinate courts, like sub-judge, district judge, or the high courts, or even the Supreme Court, there are a good number of judges who follow all these values that we talk about, who do a lot of hard work. They carry the bulk of the court's work. That you can see, those judges sit up even till 5:30, 6, sometimes 7. Those judges make sure they sign the orders before they leave for the residents. They make sure those orders are uploaded. But then there are the other lot of judges who don't do it. So there is this mismatch and this imbalance which requires correction, for which we need to put out, we need to have ways of evaluating the work of judges, putting out information on which judges actually are able to meet these standards. So you set a certain standard. We had the Maliman Committee, which set a standard of 1,500 cases per High Court judges per year, which is not much. But we should be able to analyze statistics even as a bar to find out how many judges meet that standard. We don't seem to do that exercise. I think there's much information available on the net. You have the National Judicial Data Grid that gives you the information for district judiciary. You have that grid which now has information on Supreme Court judges and some of the high courts. So we should be able to evaluate objectively the performance of judges and whether they're meeting the minimum required standard. I think I've covered most of what I want to say. I just want to end with one aspect which deters people from discussing the conduct of judges, which is about contempt of court. And I think the Madras lawyers know that best. And this has been talked about quite extensively. The whole case of Justice Kabil was on contempt of court. We just need to remind ourselves of this. This is what Lord Atkins said many years ago. The path of criticism is a public way. The wrong-headed are permitted to err therein, provided the members of public abstain from inflicting improper motives to those taking part in the administrative justice and are genuinely exercising the right of criticism and not acting in malice or attempting to impair the administrative justice they are given. Justice is not a cloistered virtue. She must be allowed to suffer the scrutiny and respectful, even though exposing comments of ordinary men. And in Bhadrakanta Mishra, our Supreme Court said, the keynote word is justice, not judge. The keynote thought is unobstructed public justice, not the self-defense of a judge. The cornerstone of the contempt law is the accommodation of two constitutional values, the right of free speech and the right to independent justice. The ignition of contempt action should be substantial and malified interference with frivolous judicial action, not fair comment or trivial reflections on the judicial process and personnel. I think we need a constant introspection into our own functioning. We must be able to set high standards. Those standards must be uniform. There must be some bare minimum standards for judicial functioning. Not only the level of the district judiciary, the standards must be even higher, I would argue, for High Court and Supreme Court judges. But there must be those standards that are followed across the judicial hierarchy, which govern the actions of judges, not just on the judicial side, but on the administrative side as well. And only then it will increase the trust and faith that is reposed in this important organ in our democratic republic, which is the judiciary, to which people turn to in large numbers even today, hoping that justice will be delivered without any bias, without affection or ill will. And the expectation of the people is that the constitutional promises, which have been enshrined in the preamble of the Constitution, will be delivered by judges at all levels. So thank you for your patient listening.
அகில வழக்கறிஞர் சங்கத்தின் மாநில செயல் தலைவர் பார் கவுன்சில் உறுப்பினரான திரு ஏ கோதண்டம் அவர்கள் ஜஸ்டிஸ் டாக்டர் எஸ் முரளிதர் நினைவு பரிசு வழங்குவார். அகில இந்திய வழக்கறிஞர் சங்கத்தின் மாநில பொதுச் செயலாளர் திரு எஸ் சிவகுமார் அவர்கள், திரு என்ஆர் இளங்கோ மூத்த வழக்கறிஞர் மாநில உறுப்பினரான திரு என்ஆர் நினைவு பரிசு வழங்குவார்.
அடுத்ததாக திரு என்ஆர் இளங்கோ பாராளுமன்ற சொல்லுங்கள்.
Honorable Justice Muralidharan, the office bearers of All India Lawyers Union, friends, I thank Honorable Justice Muralidharan for his one of the excellent lecture here. But with reference to his lecture, I wanted to say one or two things in a lighter way. We are engaging lawyers also, sometimes to take out the cases from the judges, not only to get their own notice. And Justice was making a very great stress upon the concept of justice is not only to be done, it is also apparently seen. This is often very stressed, this phrase. The end result is the judiciary got it wrong. They only do the second part. Now justice is only seen to be done. Justice is not. They kept the format. They are doing everything in their correct format, but the substance is missing. That's the worrying fact. Third, sir, you mentioned about Kesavananda Bharati's case. Thankfully, it is a 30-judges bench judgment. It is not going to be reversed. But in the parliament, I'm often hearing that basic structure theory should be given a go back. Thrice I have heard in the parliament that the basic structure should be done away with. So that's the kind of situation we are living in. I'm here to share some of the views on the three major criminal laws which were enacted by the Parliament recently. My views are completely apolitical and as an age. And before you as a lawyer, member of the Parliament, member of the committee of the Home Department, which has gone into these three bills. I was a prosecutor. I was trained by one of the best defense counsel of the country. So, viewing these three major laws in these capacities, I'm giving this speech. All of you are aware that the three major laws, namely Indian Penal Code, Code of Criminal Procedure and the Evidence Act, are now being called as Bharatiya Nyaya Sanhita, Bharatiya Nagarika Suraksha Sanhita, and Bharatiya Sakshya Abigail. It took very long time for me to memorize these words. To represent before the committee. Out of these three, Indian Penal Code is the substantive law, Criminal Procedure Code and Evidence Act. In a sense, these two are procedure laws. As a very competent lawyers, I'm not going to here give you a lecture on what is a substantive law and what is a procedural law. But even if there is one or two shortcomings in the procedural law, the judges can do something about it. But if there is a difficulty in the substantive law itself, that's going to cause a very great confusion in the society. Because enforcing a vague substantive law will be difficult. It will allow misuse of power, difficult in applying them. So the rights of the victims will be in question, rights of the accused will be in question. With this in mind, I request you to see these acts. I in fact congratulate the All India Lawyers Union for having arranged for this seminar, but because this is the right time to consider these three bills by the lawyers. When they asked me to give this lecture, I was like with a fond hope that there may not be any necessity for this lecture because at that point there was a great unrest among the truck drivers not to enforce a particular section, namely 106 of the Bharatiya Nyaya Agreement. Union said we are not going to enforce these laws. So I thought they are going to revisit the entire law. But now they have notified it to come into effect from the 1st July 2024. The three bills were introduced on 11th of August 2023 and were referred to the Department-related Parliamentary Standing Committee on 18th of August 2023. Lawyers must know that the consideration of a bill is not only confined to the House, namely Rajya Sabha, Mr. T.K. Raghurajan is one of the great parliamentarians. You should also know that these committee meetings contribute more to the making of these laws. So, Department and Committee on Home Affairs consider this for 12 cities, which in my view is very less time. Because putting all the three bills together, they only took 12 cities. At the end of the meeting, a draft report was prepared, to which Mr. Member of Parliament, Mr. Adil Ranjan Chaudhary, Ravneet Singh, Mr. Digvijay Singh, Mr. Derek O'Brien, Mr. P. Chidambaram, and myself circulated our dissent notes, which forms part of the Departmental Related Committee report. I was told that 11 out of 12 of my suggestions were taken by the unions. And the bills were withdrawn on 12th of December forenoon and reintroduced on the afternoon of 12th of December, on the same day. We are all aware, at that session, there was a pandemonium in the Lok Sabha because the two persons entered into the House chamber through some smoke pipes. So the opposition was boycotting the parliament throughout that session. In my view, because these three laws are very essential, the government should have stopped introducing and pushing for this bill. In spite of that, In the absence of the opposition, they passed all the 3 bills. And now they are notified. First, I'll tell you what are the good aspects of these laws, the new laws. As far as the Indian Penal Code is concerned, that which is going to be called as Bharatiya Nyaya Sanhita. Number 1, the punishment for sexual offences are increased. That's very good. Section 95 of the new Act is a new clause which provides for hiring of a child. A child is defined 18 years below to commit offences. So far, it is not punishable, but under new Indian Penal Code, it is separately punishable. That's a very, very welcome provision. Snatching of child is maybe a new offence. The offence of mischief, if you see offence of mischief in Indian Penal Code, Section 427 punishes the property valued above 50 rupees. 326 punishes property value below 50 rupees. That is not the modern day practicality. It's not a good law. So that section has been amended. Omission of certain sections which are no more relevant or very good welcome aspect of the PNS. As far as the CRPC is concerned, Section 86, the attachment of the properties of the proclaimed offenders, is a new section. And in absentia trial is provided under Section 326. And time-bound hearing of discharge petition, time-bound granting of sanction, time-bound hearing of final hearing, time-bound investigation, all are introduced. They are all very welcome provisions. We should, in fact, welcome them. The common defects of all the 3 acts is that, number 1, the naming of these 3 acts I thought it is in Hindi. I questioned in the committee, we can question anybody who is appearing before the committee. So I asked the Union Home Secretary, sir, why have you named these 3 bills in Hindi? He said, no, sir, we have named them in Sanskrit. I said, sir, section Article 348 is there. How can you name them? I'll show, I have that committee minutes. He says, sir, please see, we have named them in Sanskrit, but written them in English. That was the answer. I said, fine, sir, let it be so. They named them in Tamil, write in English. There was no answer. They were very, very adamant in keeping the names in Sanskrit. It is despite the objections made by all the MPs throughout the country, everywhere. MPs from West Bengal, Odisha, everybody opposed it. Government is not changing its view. So that's first drawback. Number 2, in fact, there is no necessity to amend these acts. What they have done is, they say, old wine in new bottle. I'd say this is old wine in a oldest bottle. Because Section 3, they only 300 sections. Section 300 of IPC is now becomes Section 100 of IPC. Like that, they rearranged the sections. They say we have reduced the number of sections. I was worried how you can delete so many offences. Then I found Section 1255, where the definitions of Indian Penal Code is there, totally taken away. Put in Section 2 definition. So the number of sections reduced. That is what happened in CRPC also. They reduce the number of sections by clumping so many sections into one section. That is how they done it. There are no major amendments. Wherever they claim that we achieved that, this, those provisions are totally confusing and is going to cause more confusion in the society. The object of these three acts, according to the government, is twofold. One is to get rid of the colonial laws. Number two, to enforce or to strengthen the fundamental rights of children. If you see, or if you are with me for some time, I will show how on both accounts the three laws failed us. Colonial laws means colonization is not only occupying the country or a territory, occupying or want to rule over the people also is colonization. In that sense, it is not going to the object what they say, and fundamental rights are not definitely being protected because of these three laws. In fact, the laws were introduced with so many mistakes, typographical errors, misquoting of sections. You must see Senior Counsel Mr. P. Chidambaram's dissent note. He had pointed out 75 typographical errors in the bill. Assume and think that this is the bill prepared by the Parliament of India, which has contained nearly about 75 typographical errors. Mr. P. Chidambaram was meticulous in pointing out all these mistakes. Now, before the second bill, that is on the first bill it was introduced, what they wanted to do is, we have general exceptions in Indian Penal Code. All of you must have read general exception, right? Section 84 deals with offences committed by persons of unsound mind. Okay? Judge knows and students of law knows that in our country that this unsound mind has been interpreted by so many judgments on the basis of McNaughton rules. What is McNaughton rule says? It is not medically mental illness. It's legal mental illness is the question. On the date of commission of offense, you should not understand what are the consequences of your act. That is legal insanity. There is a medical insanity and legal insanity. What is protected under general exception is legal insanity. The first bill introduced replaced the word unsound mind, and it has protected the offences committed by persons of mental illness. All right. And in the definition clause, the definition of mental illness is given as section 2S of the Mental Health Act. Mental Health Act says substantial disorder of thinking, mood, perception, orientation or memory, capacity to recognize the reality, or mental conditions associated with abuse of alcohol or drugs. This is mental illness. I asked a question, if this is so, drug addicts and alcohol addicts, 40 to 50% of the cases you cannot try because all will be allowed to go under general exception. You are having this much of liquor shops here. So everybody is claiming that I am liquor addict. Please give me general exception. You cannot prosecute any person at all. The union government realized it, that is now reverted back to mental illness to unsoundness. These are the inner mistakes which were available in the bill. Likewise, Section 23 of BNS, Bharatiya Nyaya Sanhita, if you see, that is with respect to intoxication. It provides like this: if a person is intoxicated, not on his own, by somebody else, the word used was unless. Unless prosecution have to prove that he was intoxicated. Accused prove I was intoxicated, not by myself, somebody else intoxicated. அதை கொண்டு போய் என்ன பண்ணிட்டாங்க, ப்ரொவைடர் மாத்திட்டாங்க. அப்படின்னா ப்ராசிக்யூஷனே தான் ப்ரூவ் பண்ணணும் ரெண்டுத்தையும். அவன் இன்டாக்சிகேட்டடா இருந்தா நாட் ஆன் ஹிஸ் ஓன் பை somebody elseங்கிறத ப்ராசிக்யூஷன் ப்ரூவ் பண்ணணும்னு கொண்டு வந்தாங்க. That was also on our suggestion. It was again reverted back. These are all I point out where the problems. So they are all now rectified. So let us not waste much time on that. Now we come to the present problems. If you see, if anybody is having the mobile, if you can download Bharatiya Nyaya Sanhita, go to section 103, present 103. What happened in the original bill? Murder தானே. Murder அதுக்கு நமக்கு இந்தியன் பீனல் கோட்ல நம்ம படிச்சு தெரிஞ்சுக்கிட்ட வரைக்கும் vicarious liability can be fastened in criminal law by adding conspiracy 120B, section 34 common intention, 149 common object. Correct? In the common object enginery, 5 or more persons with a common object committed offense, they are punishable as if each one of them have committed that offense. ஒரு மர்டரை 5 அல்லது 6 பேர் போய் பண்றாங்க அப்படின்னா அந்த 5 அல்லது 6 பேரும் அல்லது 10 பேரும் கூட ஒரே ஒருத்தர் தான் குத்துவார். மற்ற 6 பேரும் ஈக்குவலா லைஃப் ஃபார் 3 நாள். அது காமன் ஆப்ஜெக்ட். நீங்க எங்கெல்லாம் கண்டுபிடிச்சாங்கன்னு தெரியல. 103 2ஆ பிரிச்சாங்க. அதாவது மர்டர் பனிஷ்மெண்ட் 2ஆ பிரிச்சாங்க. பிரிச்சு whoever commits murder is punishable with death or imprisonment for life னு சொன்னாங்க. அது வரைக்கும் சந்தோஷம். 103(2) ஒன்று கொண்டு வந்தாங்க. அது எதுக்குன்னு கேட்டா, when 5 or more persons join together commit murder on the basis, on the ground of religion, race, language, etc., etc., specific conditions, then he will be punished with death, life, or 7 years of prison. நான் கேட்டேன், ஏங்க 5 பேர் சேர்ந்து ரிலீஜியன்ற கிரவுண்ட்ல கொலை பண்ணான், ரேஸ்ன்ற கிரவுண்ட்ல கொலை பண்ணா அவனுக்கு 7 வருஷமும் 1 நாள் கூட தண்டனை தரலாம். வாய் தகராறுல சண்டை போனா லைஃப் சென்டென்ஸ் மட்டும் தான் கொடுக்கும். இது என்ன நியாயம் கேட்கும். They raised that there is a mistake. So the 7 yearsன்றதை எடுத்துட்டாங்க. இப்ப 103(1) பாத்தீங்கன்னா சரி, 103(2) பாத்தீங்கன்னாலும் சரி, ஒன்னாவே தான். எதுக்கு அது 2 செக்ஷன்னே தெரியாது. 103(1)லயும் பனிஷ்மெண்ட் டெத், இம்ப்ரிசன்மெண்ட் ஃபார் லைஃப் வித் ஃபைன். 103(2)லயும் பனிஷ்மெண்ட் டெத், இம்ப்ரிசன்மெண்ட் ஃபார் அண்ட் வித் ஃபைன். எதுக்கு 2 ப்ரொவிஷன்? Will it not allow confusion in interpreting this? Then courts will sit over this. Why there is a second provision to 103? In spite of we are pointing out this, government has not rectified it. The same thing happens in section 1172, voluntarily causing hurt. இது பேசிக் பிரச்சனை இந்தியன் பீனல் கோட்ல நாளைக்கு going to put it in action, enforcing it. It's going to be a problem. The new additions of Indian Penal Code, that is Bharatiya Nyaya Sanhita, or 2, Section 111, organized crime, and Section 113, terrorist act. Organized crime, there is a problem. It is very good that you are bringing in a general law for the entire country, organized crime. But as lawyers we know, organized crime act are there in several states, namely Maharashtra, Gujarat, everywhere organized crime act is there. It's a state name. And there are special provisions prescribed in that. Bail is difficult, trial is expeditious, trial is ensured, all that. Now, in view of Section 111, organized crime is being brought in the Indian Penal Code itself. Now, all those state enactments will go. Now, they have to reenact them, get the assent of the president. Otherwise, those laws will go. This is the problem of those states. We don't have the Organized Crime Act, but few states are having organized crime will be a difficult provision to interpret in those states. Number 1. Number 2, Section 113, Terrorist Act. We have another act called Unlawful Activities Prevention Act, in which what is terrorism, what is terrorist act is defined, terrorist organization is defined. Indian Penal Code, that is Bharatiya Nyaya Sanhita, is also having provisions for terrorist act. Now, which law is to be used? FIR, if one terrorist act is committed, whether it has to be registered under Bharatiya Nyaya Sanhita or UAPA is the question. That discretion is given to the superintendent of police. So that much of executive power is given to take away the rights of the people. A person, whether he is committed the offence only under IPC or under the special act, is to be decided by the superintendent of police. That's a very dangerous proposition they want to do. Second thing, if you see Section 179 of Bharatiya Nyaya Sanhita, which says counterfeiting of notes. Counterfeiting of notes is punishable under 179. Now, if you read again, the organized crime, offence of organized crime, in Section 11111, or terrorism under 113, in these two sections also, if you are dealing with counterfeit notes, it can be either termed as an organized crime or as a terrorist act. Now, mere possession of counterfeit currencies is punishable under 3 different sections. Number 1, 179, which is possession of counterfeit notes. Number 2, it is punishable as an organized crime. Number 3, it is punishable as a terrorist act. Now, you see what are the different kind of punishments are given. For if I have counterfeit notes, the police officer now is having choice of booking me under either one of these 3 sections. 179, 111, 113. Now, police officer have to like me. So if he likes me, I am under 179. If he doesn't like me, I will go as a terrorist. Middle way, I can be named as an organized crime offender. This is what the substantial law is not clear. it is confusing, it's vague. Now, if it is susceptible for this kind of interpretation or this kind of misuse of power by the executive, this cannot be a good law. So, on that ground alone, these three sections and section 103 and 117 have to be reviewed, number one. I want to read one section from the date of introduction, that is on 11th of August, till today. I am trying to understand what they want to say in this section. That is section 46, explanation 5. They want to explain who is an abettor. Section 46, explanation 5. I read it slowly. If anybody can understand, or I request the Honorable Justice to interpret it. It is not necessary to the commission of the offence of abetment of by conspiracy, because abetment can be committed in 3 ways. One is intentionally aiding. குத்த போகும்போது அந்த கத்தியில குத்தா கொஞ்சம் மொக்கையா இருக்கு, நல்ல கத்தியா குத்து இன்டென்ஷனலி, அல்லது இன்ஸ்டிகேஷன். அவங்க சும்மா விடாதா, வெட்டிடுடா, அவன் கையில காலில் வெட்டாத, கழுத்துலயே விட்டு, இதெல்லாம் இன்ஸ்டிகேஷன். The third way is by conspiracy. கான்ஸ்பிரசினா தெரியும், முதல்ல எங்கேயாவது உட்காந்து கூடி மீட்டிங் ஆஃப் மைண்ட்ஸ் அக்ரி பண்ணுவோம், நானும் அவனும் ஒரே மாதிரி அக்ரி பண்ணுவோம், இவன் மாடல் பண்ணிடுறோம். இப்போ அந்த மாதிரி கான்ஸ்பிரசி பண்ணி அபிட் பண்ணா அது என்ன சொல்றாங்க பாருங்க. It is not necessary to the commission of the offence of abetment of conspiracy that the abettor should consult the offence with the person who commits. அதாவது கான்ஸ்பிரசி மூலமாக அபேட்மெண்ட் பண்ணணும் அப்படின்னா கன்சல்ட் பண்ணுறதுக்கு என்ன, ஒத்துக்கணும். நான் அவனோட ஒத்துக்கணும்னு அவசியம் இல்லை. இட் இஸ் நாட் நெசசரி டு கன்சல்ட் தி அஃபென்ஸ் வித் தி பர்சன் ஹூ கமிட்ஸ் இட். நல்லதா? It is sufficient if he engages in conspiracy in pursuit of that offense. Direct or contradict. Consult-னால agreement, conspiracy-னால agreement. ஒரு இடத்துல என்ன சொல்றாங்க, ஒரே ஒரு விஷயம், explanation 5ல, it is not necessary to consult to commit that offense. It is sufficient to commit conspiracy for that. இது எடுத்து சொன்னாலும் புரிய மாட்டாங்க. Self contradictory section. இப்ப ஜட்ஜ் என்ன பண்ணுவாங்க? There is no conspiracy, but consent இருக்கு. There is no consent. Conspiracy போதுன்னு சொல்லிருக்காங்க. எங்க ரெண்டுத்துக்கு அக்ரிமெண்ட் தானங்க. அதெல்லாம் பரவாயில்ல, இவங்க சொல்லிட்டாங்க, நாங்க செய்வோம். See, வழக்கறிஞர்களாகி நாம் என்ன நினைக்கிறோம், இது நாம கேஸ் நடத்துறோம், நமக்கு இருக்கிற டிஃபிகல்ட்டி இல்லை. This is going to touch upon the life of every person who is walking on the road. Accused ஆகிறவங்களுக்கும் பிரச்சனை, விக்டிமா இருக்கிறவங்களுக்கும் பிரச்சனை, சொசைட்டி அட் லார்ஜ் பிரச்சனை. இதை புரிந்து எடுத்து சொல்லணும்னா லாயர்ஸ் அது மட்டும்தான், லாயர்ஸ் தான் பண்ணியாகும். This is the correct time for us to take necessary steps. அது எந்த வகையில வேணாலும் இருக்கலாம், வழக்கு போடலாம், நம்முடைய கண்டனங்களுக்கு இருக்கலாம், எப்படி வேணாலும் இருக்கலாம். Now this is the time to rectify these kind of confusions in the substantive law. So இதுல எங்க ஃபண்டமெண்டல் ரைட்டை வந்து உறுதிப்படுத்துறதுக்காக இந்த சட்டத்தை நான் எடுத்துட்டு வந்தேன்னு சொன்னா அது எப்படி நம்ம எடுத்துக்கணும்? This is not ensuring the fundamental rights. In fact, it is taking away, because the fundamental right of the accused to be prosecuted in the proper section of law is being taken away. So this is with respect to Indian Penal Code, BNS. The BNSS, Bharatiya Nagarika Suraksha Sanhita. Section 167, அதான் நமக்கு டெய்லி நடக்கிற விஷயம். அதாவது அரெஸ்டுக்கு அப்புறம் 24 ஹவர்ஸ்க்குள்ள மேஜிஸ்ட்ரேட் கொண்டு போகணும், அவர் ரிமாண்ட் பண்ணுவார். One 167 CRPCA இது வரைக்கும் ஒரு 100 ஜட்ஜ்மெண்ட் ஆகுது. என்ன கொண்டு வந்து அக்யூஸ்ட ப்ரொடியூஸ் பண்ணா மேஜிஸ்ட்ரேட் கிட்ட, மேஜிஸ்ட்ரேட் ஹேவ் டு அப்ளை திஸ் மைண்ட். எதுக்கு ரிமாண்ட் வேணுமா வேணாமா, இவரை ஜெயிலுக்கு அனுப்பணுமா, ஜுடிஷியல் கஸ்டடிக்கு அனுப்பணுமா வேணாமா அப்படின்றத you have to satisfy himself from the records. எத்தனை பேர் மேஜிஸ்ட்ரேட் கோர்ட்ல பிராக்டிஸ் பண்றீங்கன்னு தெரியல. Can you raise your hands please? Thank you. நாங்க அங்கிருந்து பிராக்டிஸ் பண்ணி வந்தவங்க தான். இது வரைக்கும் நான் எந்த மேஜிஸ்ட்ரேட்டும் ரிமாண்ட் பண்ணும்போது ரிமாண்ட் பண்ற வேலையை மட்டும் பார்க்கிறேன். அங்க விட்னஸ் எவிடன்ஸ் சொல்லிட்டே இருப்பான். இங்க ஒரு பக்கம் அக்யூஸ்ட ப்ரொடியூஸ் பண்ணுவாங்க. நம்ம கரெக்ட் அது பாட்டு எல்லாமே ஆட்டோமேட்டிக்கா தன்னிச்சையா நடந்துருக்கு. இந்த ரிமாண்ட் ரிப்போர்ட்டை காட்டுவாங்க, டைம் பத்தல அப்படியே கைது போட்டு அனுப்பிச்சிடலாம். ரிமாண்ட் மட்டும் இல்லை, கேஸ ஃபைல் எடுக்கிறதுக்கே காக்னிசன்ஸ் ஆஃப் அஃபென்ஸ் அதுக்கு வந்து ஒரு 10-15 நல்ல சுப்ரீம் கோர்ட் ஜட்ஜ்மெண்ட் இருக்கு. காக்னிசன்ஸ் ஒரு கேஸ ஃபைல் எடுக்கிறப்ப if you are taking cognizance you have to apply your mind because it is serious issue where you are concerning the personal liberty of the person. அப்படிலாம் சுப்ரீம் கோர்ட் ஜட்ஜ்மெண்ட் சொல்லிட்டாங்க. எங்க ஊர்ல என்ன பண்ணி வச்சிருக்காங்க, ரப்பர் சீல் செஞ்சு வச்சிருக்காங்க. TOF முழுக்க கூட கிடையாது. TOF அப்படின்னா டேக் நான் ஃபைல் தான். அப்படின்னா காக்னிசன்ஸ் எடுத்துட்டாங்க. TOF ஃபைல் அப்படின்னு ஒரு ரப்பர் ஸ்டாம்ப் கொடுத்தா அது மேஜிஸ்ட்ரேட் கைது போட்டுறாங்க. இந்த மாதிரியான சிச்சுவேஷன்ல சுப்ரீம் கோர்ட் பல தடவை சொல்லி கூட மேஜிஸ்ட்ரேட்ஸ் ரிமாண்ட் பண்றப்ப அப்ளிகேஷன் ஆஃப் மைண்ட் நம்ம பண்றாங்க. அது ஏன் சட்டத்துல கொண்டு வரக்கூடாது? எதை அப்ளை பண்ணணும் ஒரு மைண்ட்? ரெண்டு விஷயம் தான் பண்ணணும். நெசசிட்டி ஆஃப் தி அரெஸ்ட் will confirm because Supreme Court says that power to arrest is one thing but necessity to justification to arrest is another thing. 506 பார்ட்ல அரெஸ்ட் பண்ணலாமா அப்படின்னா அரெஸ்ட் பண்ணலாம், அவருக்கு பவர் இருக்கு. பட் அது ஜஸ்டிஃபை பண்ண முடியுமா அப்படின்னா 99.9 வழக்குகள்ல அரெஸ்ட ஜஸ்டிஃபை பண்ண போலீஸ்காரருக்கு என்ன பிரச்சனை? நான் வெயிட்டபிள் அஃபென்ஸ், காக்னிசபிள் அஃபென்ஸ். காக்னிசபிள் அஃபென்ஸ், நான் வெயிட்டபிள் அஃபென்ஸ் இருந்தா அரெஸ்ட் பண்ணிட்டா அவராலே பிரேக் பண்ண முடியாது, கோர்ட்ல கொடுத்துருவார். கோர்ட் தானே பார்த்து ரிமாண்ட் பண்ணலாமா வேணாம் டிசைட் பண்ணும். அதை சட்டத்துல தெளிவா சொல்றதுக்கு பயப்படும். என்ன சொல்லணும்? ரெண்டே வார்த்தையில on perusal of such records and on application of mind regarding the legality and necessity of the arrest. அப்படி சொல்லிட்டா செக்ஷன்லயே சொல்லிட்டா வேற அது சொல்லல. ஆனால் அதை விட ஒரு பெரிய பிரச்சனையை கொண்டிருக்காங்க. என்னன்னா மேஜிஸ்ட்ரேட்டுக்கு வந்து once in 15 days மட்டும்தான் ரிமாண்ட் கொடுக்குது. 15 days 10 வருடத்திற்கு குறைவாக இருக்கக்கூடிய தண்டனை இருக்கக்கூடிய வழக்குல 167(2) பிரகாரம் அவர் ஜாமீன் கொடுத்தது. சார்ஜ் ஷீட் ஃபைல் பண்றாங்க. எப்ப 60 நாள் முடிஞ்ச பிறகு. 10 வருடத்திற்கு மேற்பட்ட தண்டனை இருக்கக்கூடிய வழக்குகள்ல 90 நாள் வரைக்கும் அவர் ரிமாண்ட் பண்ணலாம். இது ஸ்பெஷல் என்ஆக்ட்மெண்ட்ஸ்ல சில இடத்துல 180 நாள் சொல்றாங்க. அது நமக்கு கவலை இல்லை. நம்ம ஜெனரல் லாலே பேசுவோம். ஐபிசி எஃபெக்ட்ஸ் மட்டுமே பேசுவோம். இதுல என்ன அப்படின்னு கேட்டீங்கன்னா, இந்த 60 நாளும் 90 நாளும் 15 நாள் வரைக்கும் போலீஸ் கஸ்டடி கொடுக்கலாம். இந்த 15 நாள் போலீஸ் கஸ்டடிங்கிறது எந்த 15 நாள்? அந்த 60 நாளுக்குள்ளாக 1ஆம் தேதியில இருந்து 5ஆம் தேதி வரைக்கும், ஃபர்ஸ்ட் டே இருந்து 5th டே வரைக்கும், அப்புறம் 55ஆவது நாள்ல இருந்து 60 நாள் வரைக்கும், இப்படி ஸ்பிளிட் பண்ணி அப்பப்ப எடுத்து 15 நாள் குடிக்கலாமா அப்படின்ற கொஸ்டின் வந்து அத அனுபவம் குல்கர்னி கேஸ்ல சுப்ரீம் கோர்ட் ரொம்ப தெளிவா சொல்லிட்டாங்க. என்ன சொன்னாங்க? 15 நாள் அப்படிங்கிறது போலீஸ் கஸ்டடி, பவர் ஆஃப் மேஜிஸ்ட்ரேட் கிராண்ட் போலீஸ் கஸ்டடி இஸ் ஒன்லி வித்தின் தி first 15 days. 15 days முடிந்த பிறகு போலீஸ் கஸ்டடியை கொடுக்க முடியாது அப்படின்னு சொல்லிட்டாங்க. There are cases. In one case, Supreme Court says that accused in that case, on the date of remand itself, claims that he was medically ill. He produces certain certificates. So interim bail was granted. Then after some days, interim bail was extended. Then the judge found that this medical illness, what is being claimed is bogus one. So he wanted him to surrender. On the date of surrender, police custody was sought. He went and admitted himself in the capital of Delhi. Supreme Court found that even that admission records in the Apollo Hospital were forged. So in that peculiar circumstance of the case, it is not first 15 days, it is because the accused got these orders on the basis of forged and fabricated records. We are granting him police custody even after 15 days. அப்படின்னு சொன்னாங்க. இப்போ பிரச்சனை என்ன ஆயிடுச்சுன்னா, இந்த புது section 187ல what they did is police custody can be granted for within first 30 days if it is offense punishable below 10 years, or first 40 days if it is punishable within 90 days. இப்ப பிரச்சனை என்ன ஆச்சுன்னா, எல்லா கேஸ்லயும் 30 டேஸ்க்குள்ளாக போலீஸ் கஸ்டடி இருக்கணும். Police will wait till 29th day. Which magistrate, according to your view, will grant bail before the expiry of 30 days? In ordinary offences, 506 part 2 offences, magistrate will say, no, 30 days is not over. Time for police custody is there. I will not grant it. Because there is a provision in CRPC where it says that bail cannot be denied only for the purpose that the accused may be required for test identification for it in future. அப்படின்னு இருக்கு. Old 1973 கோட்லயும் இருக்கு, இந்த கோட்லயும் இருக்கு. Similar provision ought to have been taken. That merely because police may ask for police custody, it is not a ground for denying bail. சொல்லிருக்கு. அதையும் சொல்லுங்க. அல்லது இந்த பெட்டிஷனை 15 டேஸ்க்கு அப்புறம் போடக்கூடாதுன்னு சொல்லியிருக்கு. போலீஸ் கஸ்டடி கேட்கறதுக்கு 15 நாளைக்கு அப்புறம் கேட்கக்கூடாதுன்னு சொல்லியிருக்கு. Now what it is going to happen is, already 78% of the prisoners in India are under trials. 78%. Now what we are going to do with this is, we are going to multiply the number of under trials. Multiply into 3-fold, 4-fold. We don't have prisons. Our prisons are already overcrowded. Now, if bail is not granted, even for 506 part 2, because the police may come for a petition for police custody within 30 days, magistrates are not going to give you bail at all. So, naturally, the question flows from here is, how this amendment is going to protect or uphold the fundamental rights of the person, rather it is going to take away the fundamental rights of the person. The object for which the amendment was brought in, or object so claimed, is completely absent in these kind of amendments. So this has to be necessarily challenged in the courts, or in a democratic way, that this should be amended suitably. We have to make our protest in a democratic manner and see that these unconstitutional provisions are amended suitably. Otherwise, we cannot protect the rights of the persons. Number one. Number two, you go to arrest முடிஞ்சிருச்சா, final report போடலாம். Section 193 of the BNS, the present 173. Honorable Judge knows the problem in the investigation is the further investigation. So, the power of further investigation, உங்களுக்குலாம் தெரியும் CRPC மட்டும்தான் 1973 கொண்டு வந்தது. The old code of CRPC was 1898. Correct? 1898 code எடுத்து பாத்தீங்கன்னா there was no power of further investigation explicitly provided to the police officer. In spite of that, Supreme Court says, Ramnal 1979 Supreme Court, Ramnal says that though the Code of Criminal Procedure do not contain a provision for further investigation, yet it is inbuilt provision. So further investigation பண்ணலாம்னு சொல்லிருக்காங்க. But 1973 code வந்தப்ப 173 subclause 8 was newly introduced and gave power of further investigation. Now what happens in the new one in section 193 is this. Subsection 4 of 193 provides for further investigation at the instance of the superior officer. 193(9) provides for another kind of further investigation by the investigating officer. So now you have power of further investigation by two different authorities. Now, after filing charge sheet, inspector may say, no, I am going to conduct the further investigation. After completion of that further investigation, superior officer say, no, I want to conduct another further investigation. When the investigation will be over, this is a self-contradictory or giving power to too many authorities to conduct further investigation. Then this is the one problem. But at the same time, we must mention that section 193 of BNSS has brought in very, very good initiatives. Number one, 193(3)(h) provides first time in the country, in our mistake, that sequence of custody of electronic devices must be established. Sequence of custody of electronic device must be established. This is not there in any law so far. Number two, police officers have to inform the progress of the investigation to the victim within 90 days. That is a very welcome provision. Number three, இது வரைக்கும் ஜட்மெண்ட்ல அவராக இருக்கு. இப்ப செக்ஷன்ல கொண்டு வந்துட்டாங்க. The result of the investigation have to be informed to the victim or the informant. These three provisions are very good provisions, which are we welcome them. But at the same time, giving powers of further investigation to too many authorities is going to give a lot of confusion. Now, in the new act, two classes of judges, which are very necessary classes of judges, that cadre is totally removed. Namely, no more metropolitan magistrates. Everybody becomes judicial magistrates. Why metropolitan magistrate system was introduced in CRPC is this. The class of the kind of offences which are committed in metropolitan areas are more sensitive. There are trespass acts are there. The stakes involved are more. In the violation of Customs Act, etc., etc., and the check bouncing cases also, the stakes are more. So, senior cadre civil judges are posted as metropolitan magistrates. Now, the present system takes away the metropolitan magistrates altogether. Everybody is going to CJA. The newly recruited magistrate can be posted in jail. What will happen? That these kind of offences, special enactments, cannot be tried and disposed of effectively. Number one. Number two, the cadre of assistant session judges is taken away. The problem comes here because cases which are punishable between 7 years and 10 years, which are tried by sessions courts, are now tried by the assistant session judges. If a person is convicted, he can appeal before the session judge. If he fails there also, he can go to a division in the High Court. So because we are taking away the assistant session judge cadre altogether, all offences can be tried only by the session judge. And we have only one appeal before the High Court. If you lose there, you have to file only a session. That's first problem. From the point of view of a lawyer or the common general public. You see from the view of the judicial, the district judges, already their dockets are swelling like it. They have to take care of criminal cases, criminal trials, appeals, revisions, miscellaneous petitions, bail petitions. Thereafter, civil cases, calling work, civil suits, trial, and civil appeals. Now, because assistant session judge cadre is not going to be there, every trial is going to be there added to the district judges and additional district judges. The pendency of cases will be more, the stress on the district judiciary is going to be more. So, this assistant session judge cadre ought to have been maintained. Unfortunately, without assigning any reasons, they have taken away that kind of that class of judges. Now, one more aspect of fundamental. One right which is vested with the accused, namely the indiscriminate arrest. It's going on a seesaw every time Parliament wants to touch this. Section 40 of the old code was added with 41 capital A by 2005 amendment. In 2005, Parliament said when a police officer wants to arrest a person for offences which are punishable below 7 years, when he wants to arrest him, he has to record his reasons for arrest. Justification for arrest and reasons for arrest must be recorded with the investigating officer. That was wonderful. I don't know why in 2009 it is amended so that the police officer, when he decides not to arrest a person, he has to record reasons. Difference. To arrest a person to record his reasons in the ஏன் அரெஸ்ட் பண்ணலன்றதுக்கு மட்டும் அவங்க ரெக்கார்ட் ரீசன்ஸ் ரெக்கார்ட் பண்ணணும்னு சொல்லிட்டாங்க. That is being maintained even now. But the problem is 41 capital A notice, whether it is mandatory or not. One of the finest judgment of the Supreme Court in Arnesh Kumar says that it is mandatory. Wherever offence is punishable below 7 years, the police officer has to give notice to him. And if he is not complying with the conditions of the notice, he can go and arrest him. This position has not been strengthened. On the other hand, again now what they are maintaining is, why I am not arresting an accused in Patuna regard punishment the reasons. ரெண்டாவது அந்த அரெஸ்ட்லேயே அரெஸ்ட் பண்ணலன்னா நோட்டீஸ் கொடுத்து வரல அப்படின்னா அரெஸ்ட் பண்ண மாட்டேன்னு டிசைட் பண்ணலாம். Then you have to go to the deputy superintendent of police and get his permission to arrest him if it is within 3 years. Now, the power of arrest, which is now vested with the investigating officer, is unkept. In spite of Supreme Court says Joginder Kumar that don't arrest persons indiscriminately, there should be a justification for arrest. The parliament is not addressing that area. This is another factor which is going to increase the number of undertrials. This is the area where the parliament failed to consider ensuring the fundamental right of the persons. After this, these 2 or 3 areas in the CRPCs of the problem. The third law, the Indian Evidence Act, is like this. 65B certificate was made mandatory in the old law. Now also it is there. 65D is a different section, namely section 60. Section 63 subclass 4 gives the mandates that there should be a certificate which should accompany every electronic device. But in the annexure, the form in which the certificate should be there is given. If you see that, இது வரைக்கும் நான் 65B certificate கொடுக்கணும்னா என்ன பண்ணணும் நான் as a complainer? I would say that I have downloaded this file from my computer, which is maintained by me in a regular course of my job. And I identify my computer, it is in a working condition. I certify that I have taken a printout from this. Now, because of the new law, I have taken that certificate in a particular format, which is annexed to the Indian Evidence Act itself. Then thereafter, one expert also has to certify it. There are 2 certificates are now necessary. Now, how I am going to take an expert's certificate from the CCTV camera which is in the house? I will take out all those hard disks, go to the lab. Which expert opinion, I don't know. Because expert opinion should be in accordance with the section 71 capital A of Information Technology Act. அவங்கதான் எக்ஸ்பர்ட்டா ஒத்துக்கிறாங்க. எக்ஸ்பர்ட் எலக்ட்ரானிக் எவிடன்ஸ்ல எக்ஸ்பர்ட் அப்படின்னா he should be a person authorized under section 71 capital A of the Information Technology Act. யாரெல்லாம் அந்த ஆளு அப்படின்னு பாத்தீங்கன்னா ஃபார் யுவர் இன்ஃபர்மேஷன் தமிழ்நாடு ஃபாரன்சிக் லேப் இருக்கு, ஸ்டேட் கவர்மெண்ட் ஆஃப் தமிழ்நாடு ஸ்டேட் ஃபாரன்சிக் லேப், அதுவே இன்னும் சர்டிஃபை ஆகும். The Tamil Nadu State Forensic Lab, which is giving certificates or analysis report of all this computer disk, everything is not certified by the union government even today under section 71 capital A of Information Technology. Now, which expert is going to certify that this electronic evidence is good evidence? One hand in CRPC, very welcome provision they are making, that chain of custody have to be proved. On the other hand, in proving the electronic device, they put a hurdle saying that an expert's opinion must also be there. An expert certificate also must be there to prove that electronic device. Friends, this is only a tip of the iceberg, I can tell you, for within 1 hour's time. If you go and see, there are so many lacunas in this act. Why they rearranged the sections? What is the reason behind? In making section 300 of IPC as section 100 of IPC, as lawyers, they can have this book, which is going to give a comparative theory. அந்த காலத்துல சின்ன வயசுல இருக்கும்போது பார்த்துருக்கோம். டெய்லி காலையில பேப்பர்ல லாட்டரி டிக்கெட் பார்த்துக்கிட்டே இருப்பாங்க, நம்பர் வச்சு. அது போல we can have this comparative table with us. We can compare this. What will happen to the ordinary constable? When he will understand this, number one, அவங்க ஹேண்ட் புக் இருக்கிறது கஷ்டம். மர்டர் ஆயிடுச்சுன்னா எந்த செக்ஷன்ல அவர் கேஸ் ரெஜிஸ்டர் பண்றோம்? ஃபர்ஸ்ட் ஜூலை 2024 அப்புறம் who is going to try the entire constabulary? First problem. Second problem. Now all our youngsters are running computers. Senior சொன்னா என்ன இருக்கும்போது சொன்னாருன்னா கேஸ் லா தேவை அப்படின்னு சொன்னா 1990 இருந்து பவுண்ட் வால்யூம்ஸ் சப்ஜெக்ட் இண்டெக்ஸை படிச்சுக்கிட்டே போகணும். லூஸ் வால்யூம்ஸ் பார்க்கணும். அப்படியே 1950 வரைக்கும் சப்ஜெக்ட் இது படிச்சுதான். இப்ப அவங்க கிட்ட சொன்னா செக்ஷன் 300 போடுவாங்க, உடனே அதுக்கு எல்லா ஜட்மெண்ட்ஸும் வந்து. நான் கரஸ்பாண்டிங் செக்ஷனை பார்த்து கேஸ் தான் எப்போ பார்க்க போறோம்? ஜூனியர்ஸ் 50 நிமிஷம் மினிமம். For them to memorize and to give a comparative study of these sections and correlate with the case laws, it is going to be a very, very difficult task. இதுல என்ன சிரமம் வந்துருச்சுன்னு தெரியல. இருக்கிற செக்ஷன்ஸ் அப்படியே வச்சு எதெல்லாம் ஆட் பண்ணணுமோ புதுசா ஆட் பண்ணி போயிருந்தா பிரச்சனையே கிடையாது. இது ஏன் மாத்தி வைக்கிறதுனால எப்படி ஃபண்டமெண்டல் ரைட் அவங்க உறுதிப்படுத்துறாங்கன்னு எனக்கு தெரியல. இதுதான் பிரச்சனை.
Sedition law. Sedition law.
Sedition law. Sedition 124 செக்ஷன் அவங்க எடுத்துட்டாங்க, ரொம்ப மகிழ்ச்சி. ஆனா அது வந்து மோசமான செக்ஷனா 113 கொண்டு வந்தாங்க. There is no much of difference between terrorist act which is defined in section 113 and the terrorist act given in the unlawful activities provision act. The problem is tada potala in that advocating a terrorist act. Advocates overall and கூட்டத்துல பேசின நம்ம பொலிட்டிக்கல் லீடர்ஸ் எல்லாம் நிறைய பேர் கைது பண்ணாங்க. 1 வருஷம் 2 வருஷம் எல்லாம் உள்ள இருந்தாங்க. வெறுமனே மேடை பேச்சு. Again, advocates. The word advocates is brought in immediately. யாராவது ஒரு பொதுக்கூட்டத்துல பேசுறாங்க, he can be arrested, kept in custody as a terrorist act. 124 எடுத்ததுனால ஒரு பெரிய மகிழ்ச்சியா இருக்க முடியாது. நம்பர் எடுத்துட்டாங்க, ஆனா அதை விட மோசமான சட்டத்தை கொண்டு வந்திருக்காங்க. அதுதான் என்னுடைய கருத்து. So, as Mr. Vijay Kumar was telling me in the morning, this is let us take this as a starting point to come together and analyze these 3 acts. I think seniors like Mr. MGR Prasad and everybody have to sit together and a team has to be formed to find out what are all the loopholes in these laws and what are all the methodologies of reversing the, at least, the provisions which are having very disastrous effects. With this, I will stop my views. If my friends are having any doubt, I will hear them clarify.
One thing, typographical mistakes are rectified or not?
Rectified.
See, there's a tall claim by Mr. Shah, Home Minister. 3 வருஷத்துக்குள்ள எந்த பேக்லாக் எல்லாம் முடிச்சுவான்னு ஒரு கிளைம் பண்ணேன். ரெண்டு we have dispensed with colonial leaders ங்கறாங்க.
Colonial leaders.
I think ரெண்டுமே நம்பர். Both the claims are numbered. அதனால நீங்க சொல்ற மாதிரி it's a starting point.
How the pendency is not going to be reduced, I tell you. They say they have brought in one new provision saying that the discharge petitions have to be filed within 30 days or 60 days. Right? ரெண்டு விஷயம் கொண்டு வந்திருக்காங்க. Taking cognizance of an offense in a private complaint. உங்களுக்கு தெரியும். நம்ம போறோம், private complaint வரும், complaint எக்ஸாமின் பண்ணுவாங்க, cognizance எடுத்துப்பாங்க. இதானே? இப்ப accused have to be given notice for taking cognizance கொண்டு வந்திருக்காங்க. So, private complaint file பண்ண உடனே accused க்கு notice கொடுத்து accused வந்து appear ஆகி ஆர்கியூ பண்ண பிறகுதான் காங்கிரஸ் சரி எடுக்கலாமா வேணாம் மேஜிஸ்ட்ரேட் டிசைட் பண்ண போறாங்க. இது எப்படி பேக்லாக் சரி பண்ணும்? நம்பர் மாட்டோம். ஒரு செல்ஃப் கான்ட்ரடிக்டரி செக்ஷன் படிச்சு காமிச்சல இந்தியன் பீனல் கோட். அதுல மட்டும் இல்ல, சிஆர்பிசில இருக்கு. சம்மன்ஸ் கேஸ் உங்களுக்கு தெரியும், cases are divided into so many variety of cases. Sessions case, warrant case trial by the magistrate on the police report, warrant case on the private complaint, summons trials and summary trials. Summons trials there is no requirement for framing a formal charge. Charge frame பண்ணனும் அவசியம் இல்லை. ஃபார்முலா அத அப்படியே மெயின்டைன் பண்றாங்க. எப்படின்னா, when in a summons case the accused appears or brought before the magistrate, the particulars of the offence which he is shall be stated to him, and he shall be asked whether he pleads guilty or has any defence to make, but it shall not be necessary to frame a formal charge. அது வரைக்கும் புதுசா ஒரு ப்ரொவிஷன் போடுறாங்க. இதுக்கும் அர்த்தம் யார் சொல்ல போறாங்க தெரியும். Provided that if the magistrate considers the accusation as groundless, he shall record in reasons in writing, release the accused, and it will have the effect of discharge. Formal charge frame பண்ண வேண்டாம் சொல்லிட்டா, where is the power of discharge to the magistrate? So this is self-content. Now I am going to find a petition in every case of summons case that you have to discharge me. This is again a problem. So you can see any number of issues where they are making the law unworkable, self-contradictory. So I request the present lawyers to form a forum of senior lawyers, young